Hello and welcome to Bounce Around Charleston. Standing here with me, our legal analyst, attorney Eduardo Curry. Welcome back to Bounce Around
Thank
Charleston.
you for having me, Reverend Miller. I'm happy to be here.
Okay, we're in the Dylann Roof trial, and you know how things are now winding down. Tell us where we are at this moment.
Where we are is that the jury has found that the death penalty should apply.
Okay.
However, we're in the formal sentencing stage in federal court, where not only do they give an opportunity for the family of the victims to speak in terms of victim impact. And so they're getting a chance to do that, and then the judge will formally sentence Mr. Ruth, presumably, to the death penalty in the federal system.
Okay. Now, did he have an opportunity to speak?
Oh, absolutely. Well, his speaking would have been through direct or through cross-examination. It's my understanding that Mr. Ruth did not elect to put up any evidence, did not elect to cross-examine, actually said he wanted to be his own attorney. And so where we are at this stage now is the trial phase is over. Mm-hmm. And now what we are is at the sentencing phase. And so Judge Gergel will get a chance to hear what the prosecution say about why the death penalty should be the applicable punishment. He'll also hear about any mitigating or aggravating circumstances which affect how a judge would actually give a sentencing under the sentencing guidelines. And then from that, the victim impact statements from family members about the void of their beloved and why they believe that he either should be punished or leniency.
Okay. Now, I'm understanding that I heard that some of the family members wanted the death penalty, some of them didn't.
And there's always going to be a conflict with that. And just so that you know, the last time someone has been executed in the federal system under death penalty is probably around 2003. And in the state system under the death penalty, probably about 5 years. So the road is still long. So wow. Even if some actually say, we want him to be executed right now, that's not going to happen. He has collateral attacks and collateral appeals. So it may end up in the Supreme Court of the United States before there's ever a determination about execution through the use of the death penalty.
Now, what is the solicitor's role at this moment?
Well, in the federal system, you have the United States Attorney's Office.
Okay.
And so their role is to talk about all aggravating circumstances, and that's what they do with any additional information and particular witnesses that would talk about the deceased. And so they're going to look for aggravating circumstances to give the judge justification for giving a sentence of death.
Mm-hmm. Now, okay, he's got the death penalty that was ruled.
Well, it's ruled that he should be found guilty and have the death penalty.
Now, is there another death penalty case to come about, or?
Well, no. From here, he'll go into collateral attacks, or he'll go into the appellate process. Mm-hmm. You know, they'll have a certain amount of days to file a notice of intent to appeal, and then he'll go through that whole opportunity. And remember, it's not a fast opportunity. If you've not had anybody found or executed in the federal system since 2003, I doubt they're going to fast forward Dylann Roof to the top of the line.
Now, does the state have anything to do after this?
Well, the state wants to do some trial. They may try him for murder.
Okay.
Some people say, well, that's double jeopardy. Probably not, because you've got federal crimes and you've got state crimes. So the state, the Ninth Judicial Circuit, which Scarlett Wilson is the solicitor, may very well want to take an opportunity, as they're doing in other cases, to either try him or to make some kind of resolution of the facts.
Okay, so now, what did the families have an opportunity to speak to him in the trial?
Well, when they're speaking as in victim impact. They're impact statements, talking about the loss of their mothers or the loss of their fathers or grands or those kinds of things. And so they get a chance to address him, probably not face to face, but certainly in the same courtroom, with the ability to at least eyeball him and tell him how they feel.
Would that make an impact on the jurors?
No. The jury now system is out of it. The judge is going to sentence a formal sentencing of death or life, depending on what Judge Gergel decides. The jury has said that he should get the death penalty. More than likely, the judge is going to make a formal sentencing of the death penalty. And then from that, it'll go to the appellate process.
Mm-hmm. So is he appealing anything?
Well, we won't know that.
Okay.
He's had a very good set of lawyers that he hadn't used at trial. But in the appeal process, sometimes people go through issues, and when they go through issues, after sitting for a while in prison, after being indoctrinated to prison culture, after having seen what other people do, sometimes defendants change their mind and want to avail themselves of the appellate process. And so they'll be reviewing everything from the presentation of evidence to even whether or not he was considered competent and whether or not it was valid that the judge ruled him competent or incompetent. So there's going to be another hearing in another day, but it'll be at the appellate level.
So are we surprised at all about the outcome?
Well, certainly I wasn't surprised. And the reason I wasn't surprised is because there's a phrase that we use in lawyering, a person who represents himself has a fool for a client. And so it didn't surprise me that Dylann wasn't able to marshal the facts the way he wanted to marshal them, present evidence, because he's not trained in that area. And he had some very, very good lawyers who were trained in death penalty and appellate process and in the federal and state system. He elected not to use them. So that showed me that maybe his mindset is to go down as being some kind of martyr or go down for some kind of cause, but not necessarily in any efficiency in the trial level.
I remember there was a point that it was something talked about the competency.
Yes.
So why that?
Well, competency is defined as understanding the charges against you and being able to assist your attorney in the preparation of your defense. And so since he elected not to have the lawyer and be his own lawyer, half of the two-pronged test was satisfied. And he was clear about the fact that he understood the charges that were against him. He's made references that he never shedded a tear with regard to it, so he lacks remorse. And that's one of the things that will add to the sentencing phase when they look at, are you remorseful for what you've done? And he's been candidly clear that I am not insane and that I lack any remorse for what I did, and intimated probably that he would do it again given the same facts and circumstances, which would show someone who has a depraved heart, callous in their emotion, and certainly did not want to create a harmonious relationship between himself and the victims.
Okay. Well, we're going to talk a little bit more, but we got to pay some bills. So we want you to stay right there, and we'll be right back after the break.